Hi all, welcome to the A-Level Law Essay channel. Alright, today's video is going to be a little bit different from the ones that I usually do, as this is going to be pretty much spontaneous and it's definitely not scripted as it usually is. So this video is the first essay review video which I'm going to be reviewing, and A2 Law, Contract Law Section B Problem-Based Scenario Question. This essay sample and also the question is sent to me by one of my students, and this student asked me to review it for her because I've been thinking about actually doing essay reviews for my channel, so I thought maybe that I should let this be the first one. Alright, before we start, it will be good to actually know that this question is from October-November 2017 set 1. Alright, so if you are interested in my videos and also would like to support my channel, please do consider subscribing to my channel for more interesting videos and also other topics that may or may not actually have anything to do with legal studies. The question reads, Eric, Fabrice and Gilles collect rare coins. They all attend a specialist coin auction held by ABC Auctions. Eric is the highest bidder for a very rare bronze coin, but the auctioneer refuses to sell it to him as his bid fails to meet the reserve price set by its owner. Fabrice has seen a Roman coin listed in the auction catalogue. On the day of the auction, he arrives only to discover that the coin has been withdrawn from sale. Gilles bid more than he can afford for the scarce silver coin. He calls out to the auctioneer and he wishes to withdraw his bid, but the auctioneer does not hear Gilles and the coin is sold to him as the highest bidder. Consider whether binding contracts were formed between ABC Auctions and the three collectors and identify any remedies that might be available to them. Alright, so before I actually go through the sample answer that's provided to me by this particular student, it will be first good to actually find out what this question is all about. So as looking at it as a whole, it is definitely a contract law question, and it is definitely a question from the chapter offer and acceptance under the part of formation of contract in your contract law syllabus. So after noticing which chapter this question covers, the next thing to note is the parties here. So here we know that there are three possible claimants or parties against the people who are actually owning those three different type of coins and are trying to sell off their coins. And also one more thing to note is that this is an auction situation, right? Okay, so after that, we should also note what is the question asking us to do. So the question basically asks us to consider whether binding contracts were formed between ABC Auctions and the three collectors and identify any remedies that might be available to them. So a question like this is quite free, as in it allows you free reign. It doesn't ask you to advise anyone in particular, and so therefore your answer is quite subjective in a way, because the important thing for you to do here is that at least you go through the workings in order to get to your conclusion, whatever your conclusion is. Alright, okay, so now let's go through properly. So as I read through each paragraph, I will give my comments on them so that we can find out try to break down the contents and also review the content to see what is good and what is bad and what can be improved or taken away. Alright, so let's start with introduction. Contract law aims to compensate innocent victims by attempting to put them in a position as if the contract has been performed as agreed. A contract is a legally binding agreement enforceable at law. A valid contract requires the element of offer, acceptance, consideration, contractual capacity, and an intention to create legal relation. On the facts, offer and acceptance seem to be the main issue between the three collectors and ABC options. To consider whether there is a binding contract formed between ABC auctions and the three collectors, we shall first go through the wordings of offer and acceptance as well as each scenario individually. Alright, so this is, I would say, a standard and wholesome introduction, as usually for introduction for contracts, definitely you need to start off by giving a brief definition of what contract is, and also maybe just go through the elements of contract, especially when the question concerns with formation of contract. And then after that, it'll be good to actually highlight the facts briefly as to what happened in this scenario, but of course just very briefly. And then after that, it will be good to have a little thesis statement telling the examiner or the reader what you're going to be doing for the rest of the essay. So this introduction basically sets up the whole answer for the reader and examiner so that they know what to expect as they go through the essay. Alright, the first body paragraph. An offer is a proposition put by the offerer to the offeree which indicates the term on which the offerer is prepared to make a contract. An offer can be made to the public at large, which can be accepted by a member of public acting on the terms of the offer as seen in Carlyle versus Public Smokeball. An offer has to be certain. If the terms of the offer are not certain, there won't be a valid offer. Besides, an offer must be communicated to the offeree. Alright, so this is basically a bridging paragraph or bridging point between the introduction and the contents later. So this again develops and sets up the plot of the essay in the later part, where of course before we even go through the details of and also the details of the scenario and how it applies to the legal principles regarding contract law, we should of course definitely go in a little bit deeper on what contract is and how contract generally works. Alright, next. An offer must not be confused with an invitation to treat, which is where one party invites the other to make an offer, as seen in Gibson versus Manchester City Council. Typo here. A price marked good on display on shelf is an example of an invitation to treat, as seen in Fisher versus Bell. Auction sales also involves invitation to treat, where the auctioneer invites the bidders to bid is an invitation to treat. The bidder makes a bid is an offer, and acceptance will be made when the auctioneer bangs the hammer. Alright, you can say that this paragraph here, the second body paragraph, is somewhat related and also somewhat contrasting with the first body paragraph, which is good because here is where the answer is actually addressing the question a little bit already, especially with regards to auction sales. As we know, in the scenario of this question, it concerns auction sales, and so therefore auctions, in order to discuss auction, we definitely need to discuss invitation to treat as well. And so therefore this is a very good move made by the student in highlighting auction sales and also the principle regarding invitation to treat. And it's good that the student actually mentioned the main cases of Gibson versus Manchester City Council and also Fisher and Bell, which can actually be used to explain the legal principles behind invitation to treat. However, it would actually be good if the student did also mention at least one case with regards to auction sales specifically. Right, next, the third body paragraph. There are situations in which an offer will cease to exist, including where a specified or reasonable length of time, I think the length should still be here, specified length or reasonable length of time is up. Besides, counteroffer and rejection also cause an offer to cease to exist. Failure of a precondition also causes an offer to cease to exist, as seen in Financing Limited versus Stimson. On the facts of the case, in Eric's situation, there has been a precondition set by the owner of the bronze coin, which is the minimum reserve price. Thus, by failing to meet that precondition, which is by failing to bid for it for higher than that price, the offer made by the owner of the coin to sell the coin to the highest bidder has ceased to exist. Thus, there is no binding contract formed between Eric and ABC Auctions. Alright, so we are done with this particular paragraph. Alright, so this paragraph now actually addresses the first issue with regards to Eric's situation. But before the student actually even highlight Eric's issue, the student actually at least did give the legal principle regarding counteroffer and rejection first. Alright, and also the issue regarding failure of a precondition, which is actually more relevant in this situation. And then after that, only after highlighting the legal principle, then the student highlight what happened in the situation and apply it into the legal principle. However, I feel that there is one particular thing in which the student has actually omitted here, which is to at least give one case example which is specific to auction sales. And that case example should actually be Warlow versus Harrison 1859 with regards to the sales articles sold with or without reserve, right? So because there is some issue with minimum reserve price, so that is why this case of Warlow versus Harrison 1859 should actually be at least mentioned here in order to make this entire part here more complete. Alright, next is the next paragraph. An advertisement for unilateral contract is an offer as no further negotiation is needed for acceptance. However, an advertisement for a bilateral contract, which may mark the price of a good in catalog, is only an invitation to trade and not an offer, as further negotiations may be required, as well as that the stocks may run out. Thus, the Roman coin Fabrice seen listed in the auction catalog was only an invitation to trade. Thus, there is no obligation by ABC Auctions to auction the Roman coin, as it was not an offer but only an invitation to trade. Thus, no binding contract exists between Fabrice and ABC Auctions, who do not have to sell the goods listed on the catalog. Alright, so this one here now addresses the issue with regards to, what's his name? The other guy's name, Fabrice. Right. So this question concerns with, of course, advertisements. Okay, and of course the student mentioned both unilateral and bilateral. It's good to actually mention this thing because there is a difference, and the relevance here is with regards to bilateral advertisements for bilateral contract, as it is only treated as an invitation to trade rather than an offer. However, one thing that the student has omitted here is the case regarding advertisements for bilateral contract, and that main case should be the case of Patridge versus Crittenden. Alright, the case of Patridge versus Crittenden, 1968. Right, this is regards somebody trying to sell wild birds, and also the other case is I've forgotten what is the other case, but there's another case regarding selling of wine. I cannot remember. The book is in front of me, but the case is not here. Never mind. All right. So yeah. So that case should actually be in there. Patridge versus Crittenden, 1968. So as to make this part of the answer a bit more complete. And also one more thing that the student should at least mention is the case of Carlisle versus Public Smoke Ball, so as to contrast unilateral contract with bilateral contract, even though the student did actually mention it earlier already. Right, next. Furthermore, as a binding contract can only be formed if there is a definite offer and an unconditional acceptance, acceptance plays a part in forming a contract too. Acceptance is the unconditional agreement to all terms of an offer. Yeah. Okay, so acceptance must be unconditional as seen in Dean versus Hoffman, and it must be communicated to the offeree. However, there may be situations where an offer is revoked before acceptance can take place. Such revocation of offers generally can take place at any time before acceptance, as seen is in Routledge versus Grant. Key principles of revocation of the offer is that it needs to be communicated to the offeree, and as seen in Bryan versus Van ten Hoven. On the facts, Giles has bid for the silver coin, thus making a firm offer to buy it. He then decides to revocate his offer by calling out to the auctioneer. However, as the auctioneer fails to hear his revocation before banging the hammer, which means acceptance of the offer, the revocation of Giles of his offer is not successfully communicated to the auctioneer. Thus, this is a binding contract between Giles and ABC Auctions. Alright, so this part here is with regards to the third issue, the third person, and here concerns with revocation of offer. Sorry, acceptance and also revocation of offer. Right, so it's good that the student actually did mention about acceptance first. Alright, and also the main case of Dean versus Hoffman. And also did mention about communication of revocation, which didn't actually happen here since the auctioneer didn't hear it. But one thing that the student omit here is regarding this part where the auctioneer didn't actually hear it. There's one case, a very important case of Antares versus Miles Far East, where this case is the main case which illustrates the idea regarding communication of offer. And so it should at least be mentioned, but here it's not mentioned at all. It should be mentioned here, this part here. Right, then lastly, all in all, this is the conclusion. There is a binding contract between Giles and ABC Auctions, but there is no binding contract between the auctions and Eric and Fabrice. Alright, so this is a very quick conclusion. It would actually be good to at least highlight why, just a very brief why that these people didn't actually there is a binding contract or no binding contract for these people, so that there is a proper closure. There's no need for case examples or legal principles, but at least just a very quick why, you know. So the student took, if not mistaken, 33 minutes to finish this essay, and it's around, I would say, 3.5 pages in length, in content. Right, so generally I would say that before I address this thing, generally I would say that I'll give this student around 17 to 20 marks around there, or 18 to 20 marks around there, because the answer, I mean, is more or less spot on other than a few misses. Alright, and yeah, okay, right. Right, so address this question asked by the student. Is this a little too short? Not really, but if you were to add some of those things which I've mentioned earlier, it would definitely take up a full 3-page or maybe 3.5 page, and will be better, so that you definitely be a 20 plus mark answer. However, this one is definitely lesser than 20, even though everything is more or less there, but you miss out a few important things to make it distinguishable from a good answer, right? Excellent. I don't need a paragraph for evaluation, right? No, especially evaluation. Usually, if you've seen some of my video tutorial essay before, usually I only have a part which I discuss or evaluate the whole essay if the question is an essay question, meaning it is not a prompt-based scenario question like what we are seeing here today. Alright, so usually even if there's any evaluation, that evaluation is within each paragraph itself. Like for example, when you are actually discussing about each individual party situation, so after highlighting the legal principle, highlighting the facts, applying it into the facts, and then your conclusion is basically the evaluation already. In fact, if you talk about evaluation, you can put a bit of evaluation here, meaning in a conclusion, meaning that you actually uh, address the issue as to why that some contracts are binding and why some contracts are not binding. Other than that, it is generally a good answer, and since the student managed to finish in 30 minutes time, it is also good. So if the student is able to keep up more or less this standard for the other two questions as well, then it will be at least a high B, if not an A. Alright, so this is just my review. That is the first essay review for this channel. If you like what I've done in this video, please do consider leaving a like, and also please do share with your friends, as good things should be shared with your friends, and also it will help me with my work for the world. And if you are interested to get more essay reviews in the future or any other A-level law related topics, please do consider subscribing to my channel, as it will actually help my channel to grow, and at the same time it will also help those who are actually in need, because I'm sure there are a lot of people who do not get enough guidance but actually need some guidance in their studies. And apart from that, actually I'm open to anybody sending me their essays for review, but of course you need to scan it nicely first, and then you can send it to me via email. You can find my email and in the description below, or in the about section of my channel. And of course, with your permission, I will also review your essays like this, so that it's not just you benefiting from my review, but also everyone else. So I hope that we can all help each other. Alright, so that's all for this video. I hope to see you again next time. Thank you so much for viewing.